Good afternoon, everybody, and welcome to this webinar on whistleblowing claims and how to defend them. Hopefully that's what you're expecting to hear, and that's what you've signed up for. My name is Angus Menzies. I'm a partner here at Gunnar Cook. I've spent the best part of the last 20 years acting mainly for employers, but also for senior executives. And certainly one of the things I've noticed over the course of those 20 years is an increase in the frequency of whistleblowing as an allegation and whistleblowing detriment and unfair dismissal due to whistleblowing as claims. I've certainly noticed an uptick even in the last couple of years, both when acting for employers and when acting for employees, the relevance of whistleblowing and protected disclosures to the treatment that the employee has received. What I'm going to talk about today, firstly I'm going to give a very brief background to whistleblowing. We've only got an hour, so there is a limit to how much we can delve into the background. And then I want to break down the actual claims that can be brought, and you'll see why I believe it's important to do that. I do think that the legislation is complex, but I do think that's also something which can help employers as they seek to defend claims that are brought against them, particularly claims which they believe are lacking in merit. Therefore, I'll delve quite deeply into what amounts to a protected disclosure, which is obviously the essence of, or at the core of whistleblowing claims. And then I'll deal with unlawful detriment, which is one of the claims that can be brought. I'll also deal with automatically unfair dismissal. I'm not going to touch on things like interim relief, because we just don't have the time, and it's really not the place in this webinar to look into interim relief. But after looking at unlawful detriment and automatically unfair dismissal, I'm going to take a look at the tactics that an employer can adopt in order to, I suppose, minimise the results of an unsuccessful outcome in the Employment Tribunal, and to maximise the prospects of an outcome which the employer can be satisfied with. At the end, I think my conclusions will probably be fairly obvious from the rest of the webinar, but I'll summarise what my conclusions are, and also I'll suggest some possible next steps for employers who are interested in these types of issues. So then, why all of this talk about whistleblowing, and in particular, why do we keep seeing whistleblowing mentioned in the news? It's probably worth going back to the 1980s and 90s, when there was actually no whistleblowing legislation in the UK. There was nothing, no Public Interest Disclosure Act until 1998. So prior to that coming into force, there was really no whistleblower protection for those who blew the lid off malpractice and irregularity in their organisations. But there was a series of disasters and scandals in the 80s and 90s, and these led to their own reports and inquiries. And it was as a result of these inquiries and reports into the disasters that the powers that be and society in general, I think, recognised that something needed to be done. I mean, just to give you a flavour of the catalyst for that type of thinking. In 1987, we had the Zeebrugge ferry disaster, when the Herald of Free Enterprise capsized just as it was leaving port, with 193 fatalities. In 1988 rather, we had the Piper Alpha disaster, which was an explosion and a subsequent fire on board an oil rig in the North Sea, leading to 167 deaths. And that's still the worst offshore oil disaster that there has been in terms of lives lost and the impact on the industry. At the time, the Piper Alpha accounted for something like 10% of North Sea oil and gas production. So it was a very serious issue for the industry, but more importantly, obviously, it was serious for the 167 who lost their lives and their families. In 1988, we had the Clapham rail disaster, when a crowded passenger train crashed into a stationary carriage, killing 35 people. 1991, we had Robert Maxwell's disappearance when he went missing from his yacht, and it subsequently turned out that he had apparently plundered his employees' pensions over a number of years. Also in 1991, we had the Bank of Credit and Commerce International, BCCI, going bust and owing £10 billion. And it turned out, again, following the inquiry into that matter, that BCCI was known to be the bank of choice for money launderers and terrorists. Turning to 1995, and we had the scandal involving Barings Bank. Now, Barings was established in 1762 and was the second oldest merchant bank in the world, but it collapsed, owing nearly £830 million. And the collapse was mainly because of risky investments being placed by Nick Leeson, the original rogue trader, made famous in the film of that name and starring Ewan McGregor. He was sent by the bank to Singapore and was largely unsupervised, and it was as a result of his activities that the bank collapsed. So you'll see that not just financial mismanagement and huge amounts owing to investors, but also we've had these disasters. We had these disasters which resulted in significant loss of life and injury, and it was acknowledged in the reports and inquiries into those disasters and scandals that the internal reporting, in particular of wrongdoing within these organisations, was widely discouraged. And that's why it was felt that something needed to be done, and that gave rise to the Public Interest Disclosure Act, or PIDA. And PIDA amended the Employment Rights Act of 1996, making it illegal to dismiss or mistreat someone for whistleblowing. It's obviously more nuanced and more detailed than that, and we'll come into the precise wording of the legislation. But essentially, it was a sea change in terms of how whistleblowers were to be treated from that point onwards. And certainly since 1999, there's been a number of famous whistleblowing cases where insiders have blown the lid off malpractice in, for example, the NHS and in financial services. And more recently, we've seen with the Harvey Weinstein scandal and the hashtag #MeToo campaign that individuals have been encouraged to blow the whistle on impropriety and let's be honest, criminal behaviour. And that has not been confined to media and entertainment, but it's been the case across many sectors, including legal and professional services. And I think most of us would agree that the courage of these whistleblowers should be applauded. I think it's acknowledged that their actions have improved the work environment and the culture for many other employees and workers, and they've brought individuals to justice as well. They've seen disciplinary action take place and actual criminal sanctions being imposed as well. So that's, I think, why we have all this talk about whistleblowing in the news. Why do we have all this talk about whistleblowing in the HR community? I think, again, there's obviously HR people read the news, HR people are in corporate organisations, and all of the the hashtag #MeToo stuff and the and some of the financial scandals that we've heard about. They're read about and they impact HR professionals, but in particular, I think the fact that whistleblowers have greater protection than normal standard run-of-the-mill employees, if you like, is another factor of why HR professionals and employment lawyers have seen and are seeing, I think, an increase in whistleblowing related claims. So firstly, one of the reasons, or one of the enhanced protections that whistleblowers have is that there's no 2-year service requirement before they can bring an unfair dismissal claim. Protection starts from day one. And secondly, there's no requirement that whistleblowers actually have to be employees. They can be workers, and with all that's going on in the gig economy, it's recognised, I think, that the proportion of the workforce who are traditional PAYE employees is decreasing, and we're getting more and more people who are gig economy workers, self-employed potentially, but working solely for one organisation. And the protection afforded to whistleblowers will normally apply and cover all of those individuals as well. So actually that definition of worker, which relates to whistleblowers goes beyond even the normal definition of worker, which, as we know, goes beyond the definition of employee. So there's more people are covered under the Public Interest Disclosure Act, as it amends the Employment Rights Act. Whistleblowers will include self-employed GPs and dentists, as well as agency workers, employee shareholders, and non-executive directors, for example. And they're people who would historically not necessarily have that much in the way of employment protection. Thirdly, there's no statutory cap on the compensation that can be awarded in an unfair dismissal case where the reason for dismissal is whistleblowing. And often it's been found by tribunals in these kind of cases that whistleblowers who are unfairly dismissed find it very difficult to go back into their industry, and sometimes even very difficult to find any other job, and therefore career loss and stigma are certainly factors that the tribunal has taken into account when calculating compensatory awards. And as you can imagine, if we're looking at career loss, the potential compensation in an uncapped whistleblowing unfair dismissal case can be very, very high. As you'll know, in a standard unfair dismissal case, damages or compensatory awards are currently capped at £83,682, or the employee's income, whichever is the lower, annual salary, whichever is the lower. So as well as uncapped compensation in unfair dismissal cases, whistleblowers can also bring claims in relation to detriment. And in bringing claims in relation to detriment, which is generally treatment which falls short of dismissal, although as we'll see, it can actually include dismissal in some circumstances as well. But detriment claims, like in discrimination situations, there's not only economic loss that can be compensated, but also damages for injury to feelings can be awarded in a detriment case as well, where the grounds for the detriment was a protected disclosure or whistleblowing by the individual. I mean, it's my position that not every individual who asserts that they're a whistleblower deserves protected status, and that's going to form a large part of this webinar. It's certainly my experience with the increasing trend in whistleblowing claims, and certainly when I'm acting for employers, that whistleblowing can be bandied about in employment tribunal claims fairly freely. And my suspicion, and the suspicion of my employer clients, is that it's being included because in some situations the individual would otherwise be unable to bring a claim because they don't have the 2 years service, and therefore the tribunal wouldn't have jurisdiction to hear an unfair dismissal claim. And sometimes it's being included because of the uncapped compensation point, which means that their possible payout, if they're successful, is obviously enhanced. I think it's also fair to say that quite often when acting for employers, I've seen claims where whistleblowing is cited and protected disclosures are alleged, and it seems that the reason for doing so on the part of the claimant is more to embarrass the employer than because there's any genuine truth in the allegations being made. So I think these are all, I suppose, if you take the point of view of certain employees or certain claimants, why wouldn't they put these points into a claim form if they think they're going to ultimately get a better payout? It's either via the tribunal or via a settlement. But what I think is clear to me, and I hope will become clear in this webinar, is that the law actually provides ample opportunities for the well-advised employer to weed out these unmeritorious claims where whistleblowing is thrown into a tribunal claim, or indeed maybe forms the basis of a tribunal claim, but where it's lacking in merit. So as I say, it's complicated, and I make no apologies for the fact that the public interest disclosure and whistleblowing is a complex area. I think it's probably worth just reading out actually what section 43B of the Employment Rights Act says in relation to what amounts to protected disclosure. It says it's basically any disclosure of information which, in the reasonable belief of the worker making a disclosure, is made in the public interest and tends to show that one of the following is occurring has occurred or is likely to occur, and then it lists from A to F: criminal offences, breaches of legal obligations, miscarriages of justice, endangering the health and safety of an individual, damage to the environment, and the concealing of the above or any information about any of the above. So I think there's a number of pegs, if you like, that the employer can hold on to and can ask the claimant to develop more fully in order to firstly to understand more fully the case against it, but secondly to weed out those claims which are lacking in merit. So as I say, I think firstly let's look at what's a disclosure. Now, a disclosure has to be more than just an allegation. So, for example, if an individual tells their line manager, "You're breaching health and safety requirements," that is not sufficient to amount to a disclosure. It's merely an allegation. But if they were to say, "You're leaving equipment in a dangerous position all over the floor," for example, in breach of health and safety requirements, that is more likely to amount to a disclosure, and therefore more likely to be a qualifying disclosure for the purposes of whistleblowing legislation. All the more so if actually the allegation and the conveying of that information is accompanied by a demonstration. So if, for example, the individual were to actually take their line manager to the place where hypodermic syringes and things were strewn across the floor, and were to say, "You're breaching health and safety requirements by the fact that you're leaving this equipment in a dangerous position," that would be all the more likely to amount to a protected disclosure. So as I say, it must be more than just an allegation. It can be something where the individual is telling the employer something they already know. So it wouldn't be an excuse in defence to a claim for an employer to say it wasn't a protected disclosure because I already knew. That's not permitted. The disclosure must also be in the public interest. And this is obviously important because if an individual is simply making disclosures in relation to their own personal situation, then that wouldn't, by definition, it's not public interest disclosure, it's a personal interest disclosure. And we're not, whistleblowing doesn't protect those who merely make disclosures in their own personal interest. That needs to be, I suppose, understood in the context also of situations where an individual could make a disclosure which was not only in their own personal interest, but was in the public interest as well. And the recent case on this, where a whistleblower was protected, involved it's a case of Chesterton. It involved an estate agent who made a disclosure about financial mismanagement, which affected not only his own commission, but the commission of 100 or so, in fact more than 100 of his senior colleagues. And in that situation, it was found that although when he raised his concerns and made these allegations and disclosed the information about the financial irregularities, although it was in his own personal interest, it was also very much in the interests of over 100 colleagues, and therefore that amounted to a public interest disclosure as well. Secondly, the legislation talks about it being in the reasonable belief of the person making the disclosure. So they must have a reasonable belief that the disclosure they are making tends to show that there's been a breach of legal obligation or there's been a criminal offence, etc. And the reasonable belief of the person making the disclosures is really important here as well. And it's their subjective belief, if you like. So their reasonable belief takes into account their own experience and their own knowledge. So, for example, if you have two employees in a hospital making allegations about malpractice and disclosing information that they believe is a public interest disclosure because it demonstrates malpractice, arguably the senior consultant with years and years of medical experience in the theatre is going to be held to a higher standard of proof as to what constitutes a reasonable belief in malpractice in the theatre than, say, for example, a cleaner who may who may reasonably suspect something, but actually their knowledge and their experience means that their reasonable suspicions or their reasonable beliefs, it's a lower threshold for the tribunal to have to address. I mean, that might also be the case in situations where, if there's a disclosure in the police force regarding, money laundering. Again, the financial crime detective who's worked for many years in counterterrorism and financial crime and money laundering is likely to be held to a higher standard and ought to know more closely what the anti-money laundering legislation says than say your standard Bobby on the beat who merely suspects something. So, like I say, sometimes the more knowledge and experience of an individual, the more or the harder it may be for them to demonstrate that they had a reasonable and genuine belief that the information they're disclosing tended to show that a breach of legal obligations or crime had been committed, was being committed, or was likely to be committed. Once the tribunal has looked at whether or not there's been a qualifying disclosure, the other thing that needs to be established is whether or not that qualifying disclosure was actually a protected disclosure. So you may have a qualifying disclosure which meets all of these criteria about being a disclosure of information in the reason, made in the public interest and tending to show in the reasonable belief of the disclosure that one of those offences or breaches had occurred. But if it's not made to the correct person, then it's not going to be a protected disclosure. So qualifying disclosures need to be made to the correct people. Now, the statute also sets out who qualifying disclosures ought to be made to in order to ensure that they're protected. And in many cases, it will be the first of those people, as in it's the employer. And that could be HR, it could be line managers, it could be senior employees in the organisation. Generally, if a qualifying disclosure is made to any of those in an organisation, then it's going to be a qualifying disclosure. It could also be a disclosure to another responsible person. So, for example, if you're an auditor and you uncover financial mismanagement or breach of audit rules at a client, then the responsible person then in that situation would be the client. It wouldn't be the auditor's, the individual auditor's employer. And if the individual then makes a protected disclosure to the client, and the individual is then subjected, to mistreatment or, heaven forbid, dismissal or something like that, then that would be a detriment or an automatically unfair dismissal due to whistleblowing, subject to obviously the causal link being established. But that's not a situation where the disclosure was to the employer, it's where disclosure was to the client. There's also prescribed persons, which include the likes of HMRC, Ofcom, Health and Safety Executive, Charity Commission, the FCA, PRA, NHS England, the Audit Commission, and MPs. So disclosures to any of those as prescribed persons under the Act would also be qualifying disclosures if the content of the disclosure made it they would also be protected disclosures provided the content of the disclosure made it a qualifying disclosure. There can also, in certain circumstances, be even wider disclosure of qualifying material which can still be protected. And I'm thinking here of the media. Now, media is generally the last option, and there's a number of other hurdles that the whistleblower would need to jump through before disclosure to the media made a qualifying disclosure a protected disclosure. But just so you're aware, we can't discount it, and sometimes those kind of disclosures will qualify as protected disclosures. So, having looked at what constitutes a protected disclosure, I wanted to turn now to the actual claims which can be brought, and the first of these is unlawful detriment. Now, again, there's a number of hoops that the claimant needs to jump through in order to ensure that their claim of unlawful detriment on grounds of whistleblowing can proceed. Firstly, was the individual actually subjected to any detriment or detriments as alleged? And that would normally be a question of fact. Were they demoted? Were they micromanaged because they've made a disclosure? Were they suspended? Were they disciplined? Were they bullied? was there a denial of a reference? So again, that would be in the situation where a former worker was bringing a claim alleging a detriment. And again, as I say, those kinds of issues are generally factual and ought to be fairly easy to establish. But that won't be the end of it as far as the claimant is concerned. It's also important to look at whether or not the claim was lodged in time. And you might think, well, that's stating the obvious. But it's particularly relevant in relation to detriment claims, and especially so where there's a number of detriments being alleged and where some of them occurred during a time period, many, many months or even years before the claim was lodged. As you'll be aware, in order to be in time, early conciliation through ACAS must be commenced no later than 3 months after the detriment alleged, or the last in a series of similar detriments. And it's really crucial to look at this series of similar detriments issue where there's a number of detriments being alleged, and some of them occurred long before that 3 months prior to the commencement of early conciliation. And there's a number of reasons for this. Obviously, if you can have some of the claims knocked out at an early stage, that's great. Fewer claims to defend. But also, if some of these claims are supposedly linked to, if some of these detriments are supposedly linked to the final detriment which occurred within the 3 months prior to the commencement of the early conciliation period, and the link is somewhat tenuous, then it's worth considering, as we'll come on to in tactics, whether or not to actually ask for a preliminary hearing to see whether or not certain aspects of the claim can be struck out. And I've mentioned this series of similar detriments point, because if the detriments are not linked in that way, then they can't be treated as continuing acts over that period of time. It's a little bit similar to acts of discrimination or omissions in relation to discrimination and discrimination legislation. It's designed to ensure that claimants have a chance to, bring claims in relation to historic detriments where they've continued over a long period of time. But it's so important to ensure that there is this link between them. And in terms of the link, it's, as I say, if the individual is relying on detriments being part of a series of similar detriments, then there must be some relevant connection between the acts. So you can't have, for example, someone being, I suppose, assaulted physically because they've made a protected disclosure on the one hand as one detriment, and then later on down the line being refused a promotion. These are, ostensibly different types of detriment, and particularly so if the perpetrator of the two is somebody different in each case. I think where the perpetrator of a series of similar detriments is the same, then the claimant has a greater chance of being able to demonstrate that link exists. As I say, there's got to be that relevant connection between the acts. Ideally, you would want them to be exactly the same kind of act with exactly the same kind of perpetrator. So, failure to, for example, failure to pay a bonus every year for a period of years, and where the ground for the failure is because the individual has previously made a protected disclosure, that would probably be classed as a series of similar detriments. Query whether or not it's sufficiently similar, where you've got a situation where there's a threat to subject somebody to a detriment, whether it's to refuse them a bonus or refuse them a promotion, and then subsequently that threat is carried out. Arguably, if the perpetrator is the same, then there is a similarity between the two detriments, in that one is the threat and the other is the realization of the threat. So that's certainly a question that I think arguably would result in a tribunal finding in favour of the employee where that was the situation. It's really important where you've got this series of detriments and where you're relying on a particular final detriment being in that period no more than 3 months before the commencement of early conciliation. It's really important that final detriment, if you like, is shown to be on the ground of the public interest disclosure. Now, obviously, we want all the detriments to be on the ground of the public disclosure if you're acting for the claimant, and we want none of them to be on that ground if you're acting, when you're the employer. But certainly, in terms of when acting for the employer, if the employer can show that last detriment is not causally linked to the public interest disclosure that is being alleged, then you can actually knock out all of the other detriments that are being alleged, because it's without that final in-time detriment being on the ground of public interest disclosure, the link is lost, the link is broken, and none of the other detriments, even if they were and could clearly be shown to be on the ground of the public interest disclosure, none of them would be actually within time. So, as I say, there's a number of fairly nuanced areas in relation to detriment, which an employer, if well advised, can capitalise on, and can put the employee or the former employee, the claimant, to really strict proof in relation to each of those points. As I say, in my experience, in relation to detriment, quite often the disclosures are difficult to avoid. Often they're in writing, and often it's difficult to argue that the individual didn't have a reasonable belief that they tended to show breaches of a legal obligation. But where employers can often have a lot of success in challenging whistleblowing detriment claims is on this ground point, on defeating the causal link. It might be demonstrable that there's been a public interest disclosure, and it may be clear also that there's been a detriment. But if there are other reasons for the detriment that the employer can advance, then obviously they've got a good chance of defeating that. And it's my experience that establishing that link between the disclosure and the detriment is where a lot of detriment claims fall down. Turning now to automatically unfair dismissal, and we've seen why an employee who's been dismissed might want to allege that the reason for dismissal is whistleblowing, particularly if they've got less than 2 years service, and particularly also where their annual salary is higher than the statutory cap, and they're hoping to enhance their potential payout. And in this case, in relation to automatically unfair dismissal, the criteria are slightly different to in the case of detriment. As we saw in the detriment situation, the individual has to show that detriments were on the ground of a protected disclosure, which means essentially materially significant. The protected disclosure had a material influence, i.e. wasn't just a trivial influence on the mistreatment, which was subsequently meted out. In an unfair dismissal scenario, it's more difficult for the individual bringing the claim in that it's important to demonstrate that the reason or principal reason, the main reason for the dismissal, was actually the public interest disclosure. So therefore, obviously, it's more difficult for the employee or former employee. It's by definition easier for the employer to demonstrate that there hasn't been an unfair dismissal, either because the dismissal was for a reason which the employer advances, which might be conduct, it might be even redundancy or capability. But even if the employer's stated reason for dismissal isn't accepted by the tribunal, doesn't necessarily mean that the tribunal will automatically find that the claimant's alleged reason for dismissal is the correct one. So it's really important for the employer to have an alternative reason. I mean, there have been examples of this. For example, in the case of Bolton School against Evans, Mr. Evans wanted to demonstrate that the IT system was insecure, and he demonstrated this by hacking into the system, and the act of hacking in was found to be misconduct. and the reason for dismissal was found to be a conduct dismissal rather than a whistleblowing dismissal. So, perhaps unfortunate for Mr. Evans in that case, but the tribunal sided with the employer. Contrast that with the Employment Tribunal case of Wharton against Ward Recycling, where an individual was demonstrated that the existence of what he believed was illegal landfill activities by trespassing, in inverted commas, on his employer's land in order to show the illegal activity taking place, and he was dismissed for supposedly for trespassing. And in that situation, the Employment Tribunal decided no reasonable employer would have come to that conclusion that the individual was trespassing, and that was a sufficient reason for dismissal in the circumstances. But that's not to say that employers can't have alternative reasons, and I think, as I said earlier, it's easier for the employer to defeat an unfair dismissal whistleblowing claim than it is for the employer to defeat a detriment claim. I say there that on the slide that the burden of proof depends on the length of service, and the reason for that is that obviously if the individual has less than 2 years service, they need to prove the reason for dismissal, whereas if the individual has 2 years service or more, it's for the respondent to show what the reason for dismissal was, as in a standard unfair dismissal situation. Just one point to bring out in relation to unfair dismissal and whistleblowing. If the disclosure was actually the reason for dismissal, and that is demonstrated in the tribunal, then the fact that an employer might not believe that the disclosure was a protected disclosure won't save them. So that's a situation where the employer might have dismissed somebody for making a disclosure, even though he felt that the disclosure was simply an allegation or simply a warning, perhaps. And if the employer, therefore, in that situation didn't believe that the disclosure was genuinely a protected disclosure under the legislation, if it's the reason for dismissal, nonetheless, it will be automatically unfair. There's also been some, there has been some employers who've succeeded in defeating unfair dismissal claims where, in this situation, where they've demonstrated that the actual reason for dismissal was not the fact of the protected disclosure, but the manner in which the claimant continued to make their representation. So where the claimant's behaviour in repeatedly making accusations left, right and centre was the reason for the ultimate dismissal. In that situation, employer was found not to have automatically unfairly dismissed the individual, and their explanation that it wasn't the actual disclosure, but the manner in which the individual went about things that was the reason for dismissal was accepted. So again, there's, I think, numerous opportunities for employers to be quite creative, but more importantly to really use the legislation to their advantage when faced with these kinds of claims. And that brings us on to the tactics to be adopted in whistleblowing claims. I mean, perhaps the first one of these is to really consider about drawing out more details of the case. And I think certainly a request for further and better particulars is very often worth submitting when you're acting for, when you're the employer, or when you're acting for the employer or representing the employer. And that's because it is so complex, as we've seen, that quite often whistleblowing claims are, fairly vague, if we're honest. And whilst in some situations it might be worth waiting to see whether the claimant gets very far on the basis of their own extremely vague allegations. In reality, nowadays, most tribunals will insist on narrowing down of the issues, clarifying of the issues at quite an early stage, normally with a preliminary hearing, and therefore I think there's merit in the respondent, grabbing the bull by the horns and actually putting the claimant to the trouble, and dare I say it, maybe even expense of, producing further and better particulars. And in doing so, obviously the respondent can take a little bit of control over, the requests that are made, so they can make specific requests for specific information. And quite often it will be a case that, the individual hasn't, specified the date on which they made the disclosure. They haven't specified the legal obligation that they believe was being breached, and that the information they disclosed showed was being breached. And by that I mean they haven't disclosed either, the statutory reference, or the statutory, even the statute itself, that they believe is being breached. And these are, aspects of a claim which really should be set out clearly. So I think it's very often worthwhile requesting further and better particulars. Applying also for a specific disclosure, that's perhaps normally the domain of the claimant, who will want more evidence that, one, that they made the disclosure, and two, that they were subjected to a detriment because of it. But there may still be suspicions within the employer that the claimant hasn't disclosed everything that's relevant, and therefore, in addition to requesting further and better particulars, it may be that an application to the tribunal for an order for specific disclosure is appropriate as well. Applying for strikeout or a deposit order, I mentioned earlier about how it's important to narrow down and separate out actually the various detriments and disclosures that are alleged to have been made, particularly if it's the case that the respondent, the employer, believes that some of these detriments actually took place, so long ago that they are effectively out of time. They're not sufficiently closely similar to detriments which are more likely to be found to be in time. And where that's the case, it's very often worthwhile to apply for a preliminary hearing, to have the tribunal look at these detriments and the supposed link between the detriments, which makes for a series of sufficiently similar detriments to get the earlier ones in time, and in doing so to make submissions that the claims, or certain aspects of the claims, certain detriments, have no reasonable prospect of success and should be struck out, or have little reasonable prospects of success and should therefore be subject to a deposit order. I think anything which potentially knocks out the number of detriments that have to be addressed in the final hearing is likely to, well, it's going to be beneficial to the employer. It might also curry favour with the tribunal, who obviously are always looking to ensure that ultimate hearings are managed as efficiently as possible as well, and that time isn't wasted on claims or aspects of claims which are clearly lacking in merit. The other thing is, of course, in achieving a deposit order, it's as with requiring the claimant to produce further and better particulars or additional disclosure, you're ensuring that the claimant is putting their money where their mouth is. If they're represented, or putting their time where their mouth is if they're unrepresented, because these are not insignificant tasks that need to be that need to be carried out. Certainly to produce further and better particulars for a detriment or unfair dismissal claim in a whistleblowing scenario is not something that I would ever advise a claimant to do without legal assistance. It may be the case in certain situations where the whistleblowing aspect of a claim has been alleged really in order to embarrass the employer. And if that's the case, it might be that the embarrassment is more to do with the disclosures rather than to do with the detriments. And if it's the case that actually the employer is going to have difficulty demonstrating that the disclosures didn't take place, well, it may well be worthwhile conceding that those disclosures took place. And the reason for that is so that there's no discussion or argument on them in the tribunal, and that the argument focuses more on whether or not there were detriments, and if so, whether those detriments were on the grounds of the disclosures, or whether or not the dismissal was whether or not the reason or principal reason for a dismissal was due to the disclosures. Again, the reason for this is simply to avoid potential embarrassment and reputational damage through extensive argument and legal debate in tribunal regarding whether or not public interest disclosures were made. If you can knock that out, then sometimes that's worth doing. But bear in mind, if that is the route that you go down as an employer, you are limiting your grounds you're limiting your opportunity to defend the claim, because you're focusing predominantly on the issue of whether or not there's that causal link between detriment and disclosure. And the flip side of that concession approach would be to challenge every aspect of the claimant's case. Now, I suppose that's. I think the legislation actually lends itself to that, if I'm honest. So, if an employer believes that the claimant's case is lacking in merit, then they may well want to challenge everything by saying, there was no disclosure. If there was, it wasn't a qualifying disclosure. If it was a qualifying disclosure, it wasn't a protected disclosure. If there was a protected disclosure, well, there was no detriment. If there was a detriment, it wasn't, on the grounds of the protected disclosure. There are alternative reasons. And when drilling down into whether or not it was a qualifying disclosure, you would say, well, it wasn't in the public interest. I don't believe that the individual genuinely believes that the disclosure shows breach of a legal obligation. It wasn't made in good faith. Now, the point about good faith is not to do with whether or not it was a public interest disclosure, but it goes to the issue of compensation. Because if it's found that the disclosure was not made in good faith and was made purely to embarrass the employer, for example, or purely by way of revenge, for example, well, in those situations, any kind of compensation arising from a successful claim in this context could be reduced by up to 25%. So it's something else to throw at the claimant when challenging, every last nuance of their claim. Finally, in relation to tactics, I suppose there's always cost warnings, and I suppose these are particularly relevant where you have been able to secure a deposit order. I think you've always got to be very careful as an employer in making the employee or the claimant aware that they could potentially be liable for costs in the future if they continue to plough this furrow in the tribunal when there's no reasonable or little reasonable prospect of success. Tribunals have been known to respond adversely to employers who come down too heavily on claimants, either directly or through their legal representatives. So I think it's important that any cost warnings are moderate in tone and obviously proportionate. But I certainly don't rule them out. And as I say, where there's a deposit order already in place, that's already effectively the tribunal saying that we consider this aspect of the claim as little reasonable prospect of success. And if it goes on to find in the final hearing that those claims lack merit for the reasons that it awarded the deposit order, then it's highly likely in those situations that costs will be awarded against the claimant, which obviously goes against the normal grain in the tribunal that costs don't normally follow the event as they would in the civil courts. So I think cost warning in a letter without prejudice save us to costs that's moderate in tone is something to be considered as part of the armoury, particularly where, as I say, there's been a deposit order obtained at an earlier stage. So in conclusion, I think what I would like to say is that undoubtedly whistleblowing claims are increasing in frequency. I say undoubtedly. The evidence I have is my own caseload and also discussions with colleagues and clients generally. It seems to me to be very clear that there are more claims with whistleblowing included in them now than there were 15, 20 years ago when I was in the early part of my career. I think it's also the case that not all of them have merit. I think that where there has been genuine malpractice, and especially when this has been exacerbated by scapegoating the whistleblower, employers should focus on changing their culture so that individuals are encouraged to highlight wrongdoing and so that those in the wrong are disciplined and lessons are learned. And I think a whistleblowing policy is absolutely essential for all employers nowadays, together with training on how to recognise and support whistleblowers. Ultimately, it's not in any employer's interest for financial mismanagement, for fraud, for health and safety breaches to be allowed to take place. So it is in the employer's interest to encourage whistleblowing so that these kind of things are brought to light at an early stage and stamped out. However, if a claimant is trying it on by citing alleged disclosures as the reason for the treatment that they've received, as I think I've shown, the complexity of legislation can really prove helpful to the employer, and provided, of course, that they know how to take advantage of it, or they've got good employment lawyers on standby who've got experience of fighting these kind of battles. I think prevention is almost always better than the cure in the HR sphere, and certainly it's the case that embarrassing and costly whistleblowing claims can often be avoided. I mean, I've known claims where legal costs have run into hundreds and hundreds of thousands of pounds, and had legal advice been sought at an early stage, that could have, I'm sure, could have been avoided. So I think taking advice at an early stage, when it's first suspected that a protected disclosure might, for example, be being engineered for purely personal reasons, or indeed where protected disclosures are made and the organisation, HR, line managers, whoever it may be, believe that there's actually something in the disclosure. It's really important to take advice at an early stage to ensure that whistleblowers are supported and certainly not subjected to detriment. So that's all I was going to say. As I say, it's to coin a phrase, it's been a bit of a whistle-stop tour, but and there's a limit to how much detail you can go into, which is why I've not gone on about sort of statutory provisions or particular case names or anything like that. But if anybody is interested in discussing any of this any further, does want to know a little bit more about why I've come to the conclusions I've come to or the points that I'm making, then do please get in touch, either with me, my details are on the screen, or with your usual Gunnar Cook contact. And as I say, I'd be very pleased to hear from you. I'm just checking to see if there's any questions before I sign out, and there isn't. So as I say, thank you for joining the webinar today. I hope it was useful. I'm very happy to discuss anything that has been raised on the webinar with you individually. And on that note, I will say thank you again and wish you a very good rest of the day. Thank you.